Every year, a few hundred refusals from the Patent and Trademark Office on trademark applications end up getting appealed to the Trademark Trial and Appeal Board. In fact, maybe it's even a few thousand, but it's a small percentage of the overall number of applications and of the overall number of refusals. But an appeal can be an important tool when appropriate and when there's a strong reason to believe that perhaps the examiner's decision can be overturned. An appeal is handled by a panel of 3 administrative judges at the Patent and Trademark Office, again, in this division or administrative court of the USPTO called the Trademark Trial and Appeal Board, or TTAB. I want to break down briefly the anatomy of an appeal and all the pieces and steps that go into it. So first thing when considering filing an appeal is, do you want to file a request for reconsideration at the same time you file the appeal? Because once the appeal is started, no more evidence can be added to the record. So that can be a valuable reason for filing a request for reconsideration. Now, when you file to start an appeal, note that there's a government filing fee of $225 per class of goods or services. Once an appeal is commenced, the first step is generally going to be that the applicant writes a brief in support of their appeal. And there's rules about the formatting and the length and the timing of the brief, which is generally going to be due in 60 days after the appeal starts. And note that when you go to file that brief, the USPTO is going to charge another filing fee of $200. Then the examiner gets an opportunity to submit their brief, arguing their position to the board. And then the applicant gets a final opportunity to submit a reply brief, perhaps rebutting some points made by the examiner. The applicant can then also, if they want to, choose to request an oral hearing. Used to be done in person, recently done in video, perhaps someday will come back in person. Oral hearings in appeals are relatively infrequent, and note that in recent years, the USPTO has begun charging a fee of $500 when you request a hearing. Now, once the briefing is completed and a hearing, if there is one, is completed, then the USPTO Trademark Trial and Appeal Board will take the matter under advisement and issue an opinion or decision. That can take anywhere from a few days, which is rare, a few weeks, which is relatively rare, to a couple of months, which is most likely. 2 to 3 months is the average, which means some cases can take even longer than that to get the appeal. So all told, the appeal process generally takes between 6 and 12 months is what I would guesstimate on average appeal. Again, there's always going to be unique circumstances. No 2 cases are alike. I thought of this and it came to my attention to share these steps on the video with you because our firm recently had success with an appeal in a matter for a mark called Evolve Life Systems. The appeal number is 900-42595. And you can see, if you're watching the video version of this at ericpelton.tv on YouTube, I'm sharing some of the documents so you can see what these different pieces of the process look like. Those all come from that actual recent appeal case. Thanks for watching this video. If you enjoy our tips and information, I encourage you to please like and subscribe to our channel and leave a comment or leave a review. We want to get this information out to as many people as possible so that we can share about the importance of trademark protection and help others learn the hows and whys and whats of protecting their trademarks.